Good morning, good afternoon, and good evening. Welcome to this special webinar presentation with our guest speaker, Steve Markman. Before I introduce Steve, a few housekeeping notes. Everyone will remain muted throughout the presentation, but you can ask questions by using the chat box on your screens or by emailing them to me directly. Depending on the question, I'll either have Steve address it during the presentation or hold it until the end. This presentation is also being recorded, and a copy of the recording and the slides will be circulated to all participants following the webinar. Our speaker today is Steve Markman, President of Markman Speaker Management, a speaker placement service established in 1994 and based in the Boston area with an international outreach. Speaking engagements are obtained for clients and events held worldwide, and some of Steve's law firm clients have included Ropes & Gray, Wilmer Hale, McGuire Woods, Benish, Sullivan & Worcester, Wolf Greenfield, and small to medium-sized firms. He has 30 years experience in the speaker conference industry and frequently writes and lectures on the subject of speaking engagements. So without further ado, Steve, I will pass it over to you.
Thank you, Lindsay. I appreciate it. Thanks for having me. Delighted to be here, and thank you all for listening. I know we have a combination of marketing executives from various law firms as well as attorneys themselves. So most of my remarks will be geared toward the attorneys, but obviously the marketers in the audience will understand that this is an important endeavor, and I know you do because that's why you've registered. So let's get started. So most attorneys have recognized the value of holding seminars and workshops at which they can make presentations on a variety of topics. The problem with these seminars is that more often than not, the law firm is preaching to the choir. They run seminars, law firms run seminars on their own, typically, and so the attendees at these seminars usually come from existing clients or prospects that have been previously identified by the firm. So what law firms need to do is expose their expertise and practice groups to new prospects for their services. One of the best ways to accomplish this is to speak at public conferences and meetings produced and sponsored by event organizations, associations, professional and industry trade groups, and academic institutions. By speaking in front of an audience of prospective clients, the attorney demonstrates his or her expertise, often resulting in the attainment of business. You'll be instantly recognized as an expert. The key to the success of a speaker program is to identify and secure speaking engagements with audiences of business executives or whomever buys your firm's legal services, not just other attorneys. That said, there is often value in speaking at a CLE event. For example, those that are run by CLE organizations or by bar associations, because there can be referral business attained depending on whether or not the attorneys in the audience are deemed your competitors or not. I've had clients who were in immigration law. Not everybody does immigration law, so speaking at a CLE program for that particular attorney who had his own small immigration law firm was very impactful because he got a fair amount of referral business from other attorneys. But by and large, to get the most value out of a speaker program, you should be targeting not other attorneys from law firms, but the audience that typically buys your services, i.e., general counsels of companies, or it could also be, of course, the line managers of whatever industry you might also have a lot of experience in, be it life sciences or technology and so forth. Okay, so now let's talk a little bit more about why speaking can be an effective business development and branding tool, which is what you should have the slide in front of you, basically why speak. So as I mentioned, speaking opportunities for attorneys represents a strong marketing, public relations, and business development tool. For these reasons. First, attendees learn about a firm's or specific attorney's expertise firsthand and can interact directly with the attorney immediately before or after the presentation. an attendee asking for a business card can be the first step to attaining a client assignment. Even having attorneys from other law firms in attendance, as I mentioned, can have a benefit, since some of them could be potential partners also in certain practice areas. So, number 2, gaining increased visibility in practice areas that the firm has determined is in need of greater exposure. Number 3, the firm gains advertising by having its name and the attorney speaker's name published in the agenda, both in print and online. This exposure also helps demonstrate to your current clients that you are very knowledgeable in your field. I've had many of my law firm clients go into a meeting with a prospect or even with a current client and let them know that they were about to speak or they did speak somewhere, invite them to attend, that sort of thing. So it adds to the credibility of the relationship with the prospect or with the client. Okay, so I'm going to just run through the 8 steps that form the crux of my webinar today, and then we'll go over each one separately. And feel free to ask questions. As Lindsay mentioned, I don't mind being interrupted with any question at all, and I can stop and answer. If it's something that I plan on covering a bit later, I will let you know that as well. So the 8 steps are, number 1, develop a proactive speaker placement program. Number 2, decide which subject area or areas you should target for increased visibility. 3, get the right speaker or speakers on board. 4, speak to the right audience. 5, decide on the geographic area to target for speaking engagements. 6, create high-impact presentations. 7, learn the process for submitting a speaker proposal. And number 8, follow up continuously and persistently. Okay, so let's get started with number 1, develop a proactive speaker placement program. Okay, so it's fine to evaluate unsolicited speaking opportunities that come in over the transom or might come to the firm's marketing or public relations department or directly to the attorney. But having someone dedicated to the task, whether it's internally or externally, who will aggressively identify opportunities, develop relationships with event organizers, and submit speaker proposals should lead to an increase in the frequency of speaking engagements and thus increased visibility for the attorneys participating in the program as well as the firm as a whole. So there's personal branding and practice branding as well as advantages for building the awareness of a company, of a law firm, I should say. And sometimes it's you want to be known as a go-to firm, but you're not quite there yet. So this is a good way to do that. Or you want to cement your reputation as being the go-to firm in a particular area or practice. Okay, so let's go now to step 2, decide which subject area. Okay, so you need to decide which practice areas the firm should be targeted for increased visibility. This can be an established practice where the firm speaks from a position of strength and is known as the go-to firm, or it can be a practice that's just getting off the ground or even at an early stage in development. And you need some fast exposure to let potential clients know that they can get legal counsel in an area for which they previously had to go elsewhere. They had to go to a different firm. Okay. Step 3, get the right speakers on board. So what I mean by that is that the proposed speakers should be experienced attorneys who preferably are also experienced speakers. So what happens a lot of times is I get a lot of clients, whether they're law firms or consulting firms. I work with a lot of different professional service firms of all type, including IT and so forth. And oftentimes, especially in the IT world, they're not used to being in front of an audience. Many lawyers, obviously trial attorneys, are in front of an audience all the time, right? It's just not, you just don't call it an audience, but it is in a trial situation. So there is a false sense of thinking in some cases where people think that they have to be a great speaker or they have to have a long list of speaking engagements. And even though someone may have a huge amount of experience as an attorney, they feel that they need that speaking experience in order to even be considered for a speaking slot. And that is almost never the case. What is the case is that people are looking, meaning the conference organizers, are really looking for someone who has expertise in their field. If someone is a partner of a firm, that person is going to have a better chance if they have been practicing in their sector or their area of specialty for a dozen years or so. They'll have a better chance than an associate, for example, who may actually have had a little bit more speaking experience because maybe they spoke locally or they spoke at some small meetings, but the main criteria is going to be the work experience, not so much the speaking experience. However, if you have both, if the proposed speaker has a lot of work experience, a lot of experience as an attorney, and also has a lot of speaking experience, by a lot I mean 3 or 4 or 5 places where they've spoken. It could have been to an ABA meeting, it could be to a local city, county, or state bar association, it could have been to an industry group. All of those are fine, and when you submit a proposal, you should have a list of those speaking engagements. That's really important. And the second bullet on here is get the full commitment from participants. So what happens sometimes is I get hired by a law firm, by their head of marketing, marketing director, or CMO, and they go to the attorneys that had originally thought that they were interested in speaking, but they find that they're too busy, they don't want to go away from billable hours, which is totally understandable, but in order to make this work, the commitment from the lawyers has to be there so that if the speaking engagement comes your way, you are able to accept it. And obviously, if there's a pending court case or the attorney is too busy, they might ask somebody else to do it or might have to pass on it at all, totally, which you need to try not to do. You need to try to keep an engagement once it's accepted because it otherwise gets a bad view of the situation and makes it harder to keep getting other engagements with that same organization. So the commitment is obviously important. Okay, we're going to now go to step 4, speak to the right audience. So what you want to do is you want to thoroughly research the events for which your firm's attorneys, or if you're an attorney yourself, where you can be proposed as a speaker, either as a solo presenter or as a panelist. There are countless events on so many topics that in order to maximize the time and expense associated with speaking, you need to choose which ones. So you need to decide who is the audience. That's the first thing. So client and customer prospects or recommenders. General counsels could be the primary prospect. It could be an industry executive, as I mentioned before, which is the second bullet, choose by industry and by function. So, for example, I had a client several years ago from one of the AmLaw 100 firms, and he was the partner in charge of the cybersecurity and data security and privacy practice at this international law firm. And so I was able to get him a speaking engagement, several speaking engagements to the audience that he was looking for, which was primarily people involved with privacy. There's the International Association of Privacy Professionals that I proposed for him and got him a speaking engagement. There's the Society of Information Management, which was comprised of IT executives as well as CIOs of corporations. So he was able to speak in front of those types of audiences by the industry and function, which is bullet 2 there, that really exposed him to potential prospects that were interested in his topic, and if they were grappling with a cybersecurity or a breach issue, which was his topic, then they would be able to contact him. Okay, so now you want to identify speaking engagements whose audience represent the individuals your attorney really want to speak to, as I mentioned, and you want to decide if your firm should speak to, with that audience, do they want to speak to only high-profile events, or do they want to speak to a local chapter of a key industry association? They both have value. Speaking at a national conference, obviously people are coming there from most of the country, regardless of what the country is. When I say national conference, it could be in the United States, it could be in Denmark, it could be in the United Kingdom, wherever the case may be. It could be a national conference. But there's also a lot of benefit to speaking at the local chapter of a key industry association where they discuss legal issues or where you have a proposed topic that is going to be really germane and hit the right buttons. Okay, so now we'll go to identifying opportunities. So the way I go about identifying opportunities is a couple of ways. I have my own sort of proprietary databases built up over 30 years of being in the field for different topics and different industries and different functions. But for the general public, and I use these as well, Google is really can't be beat. I mean, it's really for every facet of researching conferences a very good tool. And you know, a simple typing in mergers and acquisitions conferences, for example, or life science legal conferences, or intellectual property conferences. You're going to get pages and pages of stuff, typically internationally. And then there are directories that are international in scope, and you can search by type of industry, type of topic, as well as geographic area. So tsnn.com, allconferences.com, bvents.com. Those are the ones that I like. The next bullet is Google Alerts. And so what I do is I have I get too many emails, and that's gonna you could probably imagine that because I'm on all these alerts. But I have to do that because that's my business, and if you narrow down your field, you can do it in a manageable way. So for those of you who are not familiar with Google Alerts, it's basically if you go to the Google website, you go to Google Alerts, and you can get alerts on a daily basis, weekly basis, and every 5-minute basis. So whenever there is an announcement of a conference or some important development in your field, that's what you'll get. In the case of conferences specifically, you can do a Google alert for intellectual property conferences, or mergers and acquisition conferences, or business conferences. Anything, or just legal conferences, and you'll get a lot of what is called call for presenters, and I'll discuss that in a few minutes. When I talk about process, that's actually number 7. But you'll be getting alerts. I get them once a day. They accumulate them. I don't want to get one every 5 minutes or 10 minutes, so I just get them all at the end of the day or at some point during the day, and it has announcements of conferences, or mostly call for papers or call for presenters. And I'll get into that in a few minutes about how you respond to those. But at least you'll find out about it, and then you can go follow the link, and you'll get the detailed information about it. And in association listings, I mean, that's another way. If you go to the specific associations, that your practice is in, you can find out, obviously, all the conferences that they do. Just as if you went to the ABA conference, you'd see all the regional and national conferences that they do. Same for any industry association that you might be targeting. This is an example of some events that I used for an attorney client of mine that was interested in advertising law. So I got him into a bunch of different conferences that were specifically on advertising and marketing, and he would cover the advertising law aspect of it. So Sales and Marketing Executives International, BMA, the Conference Board, and various industry events. CTIA, this individual had a particular expertise in technology, and so I was able to get him into that one. If you have a good client base in a very specific industry, like restaurants or the hospitality industry, you could go to the National Restaurants Association and see their conferences. They usually post when they're going to be far in advance. They don't tell you the process of how to get into them. That's something that they expect you to figure out pretty much on your own, or have your marketing folks or any external people that you're using know that you're interested in that event if they haven't already figured that out. Okay, so step 5, you want to decide on the geographic area to target for speaking engagements. So as I mentioned before, it could be local, could be regional, national, or international. You may want to be known in certain cities. So if you have offices, let's say, in Detroit, New York, Chicago, and Boston, you probably are known in those cities, but you may want to be even more well-known for certain practices that you're not. And you may want to target cities that you don't even have an office in yet, but this could be a way to be a precursor to the opening of an office in Charlotte or San Francisco or wherever the case may be, London, wherever. And you look for conferences or events. And when I say conferences, I mean any event where there's, 30, 40 people or more. It doesn't have to be a full-fledged conference, as I indicated. It could be a luncheon meeting, a dinner meeting, a breakfast meeting of an association that happens to have a chapter in the city in which you want to be known and you want to target. So you would do the research necessary to find out who that person is that runs that association's chapter. There's typically within a chapter, there's usually someone who is the head of luncheon meetings or dinner meetings. They may have a title of education director or professional development director for their chapter. They're typically not full-time people. They're not part of the association necessarily, but they're on the board of directors of that local chapter, and you would find out who it is. So it's typically, it would be, for example, it could be an executive, or even if it's a law association, it would be a lawyer who has a day job. That's different, but their voluntary job is to run the programming committee. So you look for somebody with those titles, professional development or programming head. Okay. All right, so number 6 is create high-impact presentations. So one of the things that firms of all type, I've had many clients that say that when I say in the first conversation, well, what can you talk about? And they say, I can talk about anything. So that's the kiss of death to a conference organizer, because one's bio, which has to be a requirement to send when you're pitching yourself to be or if you have someone doing it for you when you're submitting a proposal. The bio is very important, but it is actually equally important to have a very specific topic with a title and a description. and it's in industry parlance, it's called the abstract. It's sort of a leftover from 100 years ago when people started to give formal presentations, actually even way before that. I think Thoreau was considered the first speaker, so probably more like 150 years ago or more. And they were mostly at colleges and universities, so they called it an abstract, which is sort of an easy phrase because it's a short version of a written paper. But that term abstract has stuck, and so what happens is you get conference organizers saying, I need an abstract. So basically what it is it's a 2 or 3 paragraph description of what you're going to talk about, right? So it's a couple of paragraphs, and maybe it ends with some bullet points that summarize what the audience is going to hear, some takeaways, in the language of the conference industry, they ask for takeaways. What is your audience going to take away from having heard a good presentation? So you need to have that outlined. You need to have it put together, and have that forms the core of your presentation proposal, the abstract as well as your bio and any other supporting information like your articles. You might have 1 or 2 good articles, recent articles, and you may want to submit those either by a PDF form or a link. So as far as the topics are concerned, sometimes I have, I help my clients get to understand what topics they want. They say, well, I can talk about anything, and then I say, well, narrow that down. And they say, well, what's the best way to do that? And I say, well, what do your clients want, right? So, what is it that your clients are asking for? So it could be how-to or legal trends or legislative updates. What they don't want to hear is that your firm is the leader or in this or that subject area. The most important thing is that it's a solid, informative presentation, and that will create instant credibility, and it will make unnecessary the need for a sales pitch. And if a presentation turns out to be a sales pitch, it's really the kiss of death. It'll ensure low evaluations by the audience and a one-way ticket home from the conference organizer. So you want to create a presentation that offers information that adds value and is not the same run-of-the-mill talk that's given all the time on a particular subject. So you want the presentation to stand out. One of the ways that you can add value to a conference and increase your chances of getting accepted, whether it's a small meeting or a large conference or meeting, is to do a co-presentation with a customer or a client, I should say, where it makes sense, where it's allowed by the event producers to have someone come in and talk about how they may have gotten a patent and what went into the development of the product and how it took so many years and the refinement and sort of the battles in the courts that happened, and then have that person be the IP attorney from a company, from a client company, would be great. And then the IP law firm attorney comes in as part of the same presentation and talks about trends in IP law and gives an overview. And you could have usually the partner of the law firm speaks first, gives that overview, and then introduces his client to give a good example of some of the things he or she was talking about. Okay. Okay, so let's go to step 7. I'll pause for a minute to give you a chance to write some notes or think about some questions, and then I'll continue. Okay. Step 7 is learn the process for submitting a speaker proposal. Stick to the format. You'll save the organizer time and make a friend. And then tailor the speaker proposal to the audience. So you first want to identify the program organizer, meaning the person within the organization that you're targeting. And then you want to follow carefully the established format for writing a presentation abstract. So you want to submit a summary of the required length that was asked, a bio, and your expertise. And you also want to have a separate document that has your previous speaking experience. And, of course, you want to meet their deadline. That's certainly key. So most law firms have a bio on the website, and that bio is quite long. Oftentimes, it's like a CV more than a bio in most cases, and so you've got a few paragraphs. I've noticed, I'm assuming for competitive reasons, that almost never does a bio. In fact, I'll say never, not almost never. Never have I seen a bio on anyone, on any attorney for any law firm on their website that says what their previous experience was if they were with another law firm, and I understand why. So, however, that is important information. And so when you are sending the bio to a prospective organization that has conferences and meetings, and you want to submit a proposal to be a speaker, you need to do a separate Word document or PDF of your bio, and it cannot be it should not be a replica of what you have, of the very long bio and CV on your website. Again, because in some cases it's too long, and in some cases it doesn't have enough information. So they're not really looking at the cases that you've been involved in as much as you might think. That they want to see what your expertise is, your education could be a factor, what speaking experience you may have, and some of the writings that you've had. So what I would do is create a two-paragraph bio in a Word document. You can make that into a PDF as well, again, separate from the bio that you have on your website. But then within the body of the email, when you are submitting a proposal and you're talking about yourself, or if it's a marketing person doing that for you, then you can and should link them to the website bio. So this way the decision maker gets to see both. They see the long version and they see the short version. And in the short version, you should include your previous positions and the firms that you work for, whether they're other law firms or companies. Okay. So what I want to talk about now is the formal and the informal process. This is all part of Step 7. And so there's let's talk about the formal process for a couple of minutes. The formal process is there is something called a CFP. It's sort of like an RFP, but it's rather than a request for proposals, it's a call for proposals. And this call is also called a call for abstracts, or a call for speakers, a call for presenters. It goes by many different names. The first word is almost always call. And so what you'll see when you get these Google alerts, if you choose to do that, or if you're on an association website, you'll see that there's something called, there may be a conference information button, and then it'll say in a bold headline, call for presenters, deadline December 19th, say. So you click on it, and it will take you to a page on their website that describes in detail what their criteria is, what they're looking for speakers, and whether there's some preset topics that oftentimes there are. More times than not, when these conferences put out a call for papers, they want to hear from people, all lines of business, whatever the conference might be. they want to hear from potential speakers as to what ideas they have for conferences, or I'm sorry, for topics. So you may be, have a bunch of hot buttons that your phone is ringing off the hook, hopefully, by your clients because they're having trouble with something. And so, a piece of legislation may have just come out. When the Affordable Care Act came out, obviously there were a lot of things for, benefits attorneys and the like, and HR and labor attorneys, and there was a ton of stuff that was going on that needed explanations. So that can help you decide the topic. But whatever it is, you may see that listed there, and if not, don't worry. Even if it's not on a list of here, they may say, here's an idea of some of the topics that we are looking to cover. Even if you don't see your topic, you should submit it anyway. And then there'll be a link to the actual form. And I'm sure many of you, especially in marketing, have seen these hundreds of times. But for the attorney that hasn't seen them, basically it's a multi-page application almost to fill out, asking for the speaker name, the bio that you can cut and paste, the description of what you're going to talk about, as I mentioned before, crucial, and some of the other information. Sometimes they ask for references from people who have heard you speak. If you have those, that's great. If you see that in your particular field that seems to be a question that's asked, you should probably try to get those as well, so you have them. And they may ask for video. So even though these are all unpaid speaking engagements that you're using for business development and marketing and PR, sort of all wrapped up in one, the key thing here is that you want to be able to, if you can, make a good, even short YouTube video so that people see that you're coming across as an interesting person and as an interesting speaker. So that would be a good thing to have. In unpaid speaking engagements, it's becoming a little bit more common to ask for videos only because it's so easy to make them. Years ago, they only asked for videos for paid speakers. So that's the formal way to get a engagement where they have a call for papers. The informal way is more what you'll see for local and regional conferences than national conferences. National conferences typically in all fields, whether they're in law or in a particular industry, most of the time they have a call for presenters, and you have to fill out that form. But if it's the local chapter of the Society of Information Management that I mentioned before, or if it's the local chapter of the Association for Corporate Growth, which has a lot of folks, anyone who's in M&A, I'm sure will know ACG and will have probably attended some meetings, and ACG has chapters all over the U.S., certainly. I believe they have some overseas chapters as well, and you would want to go to that chapter and on the website find out who is, if they have that information. If not, you have to, send an email or call and find out who's in charge of making the decisions on the programs that they have, the lunch, dinner, breakfast, whatever the case may be, programs where they have speakers come in. And so that I call that the informal process because there is no call for papers. They don't necessarily, the conference people or the programming committee, they go out and they look for these speakers, and they have a committee that comes up with ideas. But they'd probably love to hear from law firms or any buddy who's got representing speakers, because that's what they're always looking for speakers, sometimes a year ahead of time, even for local chapters. And it's an informal process because there is no call for papers. You just need to submit to the person. Once you've identified who they are, you need to submit your information, and you just do it all by email. So instead of cutting and pasting your presentation description and your bio into this form, you would maybe making an attachment, basically. You send an email. The body of the email is your one place where you can do a little bit of promotion of the attorney, of yourself. If you're not the attorney, you need to use the body of the email as the one place that you can talk about the speaker and say attached is the bio and the presentation abstract and any articles that you want to send, any links to cases that have been written up, anything that's going to give credibility to the speaker. So where I can, I much prefer doing it by email rather than filling out the form, because the form is limited, and also even the description of the talk, sometimes they specifically limit you to a certain word count or character count, and you can't even say the whole thing that you want to say, and you spend a lot of time just trying to figure that out, how to say a lot in a small space. So that's something that I have to oftentimes run up against for clients. Okay, so now we're going to go to step 8. So follow up continuously and persistently with the event organizers, because what you want to do is you want to gain mind share and have your firm stay above the noise, since you'll be competing with other law firms for the same speaking slot in most cases. By staying in touch with the program organizer, you'll increase your chances of being elected or selected to speak. And if there's your PR department has a press release, if you are getting to be accepted, that would be great to have before the talk, or a press release after the talk that is not a sales pitch, but is a way to let the press know that someone spoke about this particular topic, and more importantly, here's what they had to say. If you do it in advance, it's here's what they will say. So it really becomes a newsworthy type of endeavor. Okay, so you want to maximize the speaking opportunity. That's really crucial. So even if speaking engagements are successfully attained, you want to make sure that it has shelf life. So the way to do that is you have to be armed with takeaways. You have to have articles or white papers that you can actually hand out. It's really important. A lot of people don't do that. Even if it's a copy of your slides, what you'll do is you'll avoid having to have someone in the office be pummeled with phone calls and emails asking for the slides. So that may happen anyway if someone had to rush out, but to the extent that you can give a copy of your slides to the audience, that would be great. Or an article or a white paper that's fairly recent and that they can put on their shelf, so that if 2 years from the time you gave your talk, they've got an opportunity to or need to have an attorney or to talk about some legal issues, they won't be sitting there saying, I saw that person, what was their name, and this way they'll pull it off the shelf or take it out of a file, and they'll recall who that person was. Hopefully, one of you folks or an attorney for one of the firms listening in. Okay, so the thing that you also want to think about, and not always easy, there's an expense involved, is to have a colleague attend to, so to speak, work the room. If you've got an opportunity to do that, I suggest that be done, and also have the opportunity, if you can, to do some networking. So the conference itself, if it's a large conference, and let's say it gets a couple thousand people, and they have a lunch or they have a networking evening soon after your talk, I know obviously everybody's very busy, and there's a tendency to run out right after the talk and hop on another plane or do something else for the business. But to the extent that you can, or have a colleague that can stay and network with folks, so that you've got your speaker badge on and people come up to you, that's a way that a lot of my clients have actually gotten business. They wouldn't have attended the conference otherwise, and because you're most likely going to get a free ticket to go to the conference as a speaker, that's typically what happens. There's some conferences that actually make you pay for the conference to get a speaker opportunity. I mean, to even attend. That's something that you have to think about that would help. And business cards, of course, lots of business cards. That's really important. And there is one other thing that I wanted to discuss before we close out. My contact info is next, so this is the last slide. So what I wanted to also mention is that what is happening more and more over the last, I would say, 5 years or so, 5 to 10 years, is that large conferences are having a requirement for any kind of professional service firm to be a sponsor. And sponsorship is a really good thing for the right audience, and if your target audience is going to be there and you're making a presentation, to be able to be listed as a sponsor is a great thing. What's happening, unfortunately, over the last few years is that you're getting a requirement that in order to get a speaking engagement, you have to have a sponsorship. That's not true with all conferences. There are still many that are not what's in the industry called pay-to-play, but many of them are. And then you have to make a decision. Do you want to make that investment so that you get a speaking engagement or not? And my advice is that you take it on a case-by-case basis, you see what the return might be, and you also try to make sure that you don't ever be a sponsor without getting at least some speaking platform on the conference. So that concludes my webinar. I'm going to put up my contact info. If anybody wants to contact me, anyone who's listening in today, I'm happy to spend a few minutes talking to anybody at no charge about their company and what I might be able to give you in terms of information that would be of help to you. Feel free to email me or call me. And I thank you all for listening. And if there's any questions, Lindsay, you can let me know now.
Thanks so much, Steve. That was great. There is one question, and that is for anybody who's speaking regularly, or even people who are maybe just getting started with speaking. I think YouTube and things like Vimeo have become very helpful in showing some recordings. Is it helpful, do you find it helpful if people have short recordings of either speeches that they've done or some samples of just recordings they can do in their offices that they can send to conference organizers who might be interested in securing them as speakers? Does that help the process at all?
Yeah, it does. The requirement to have a video isn't always there, but even if it's not asked, I would do that. As I mentioned, if you have even a 3-minute YouTube or Vimeo, done on a good quality cell phone, it's certainly helpful, because it shows that you come across in a way that is interesting, and to the extent that you that the speaker or the attorney talks for 3 or 4 minutes about a particular aspect of the law, that would be great. You know, the key thing here is, you know, not a sales pitch, not to talk about, you know, our firm has this or our firm has 150 lawyers and we're the preeminent, et cetera, et cetera, et cetera. That's to be avoided at all costs. But a video of several minutes that talks about some trends in the law and shows that the attorney comes across as an interesting speaker, that would definitely be helpful. Absolutely, and you can, you know, that can be sent in as a link. It's easier to do. Absolutely.
Great. Thanks so much.
Sure.
I don't see any other questions coming in at the moment, but as Steve mentioned, feel free to reach out to him by email or by phone, and I'll provide his contact details in the follow-up email that I send as well. We'll be sending out the recording and a copy of the slides to everyone who's participated today, as well as everyone who's signed up, and we look forward to speaking with everyone again soon. Thanks again, Steve. This was great.
You're very welcome. My pleasure. Thanks for having me, Lindsay, and thank you all for listening.